Do you have it there?
So at the bottom, Dr. Mulutsi, there's a share screen that's in green. It's highlighted in green. If you just hover your mouse towards the bottom of the Zoom screen.
Yes, I'm doing that.
Okay, if you click on that, you need to click on, there's two buttons there that say share computer sound and optimize screen sharing for video clip. Just click on those two as well.
Can the host allow me to share?
I'll check in with her.
Because it
Nikita?
doesn't. Maybe they're still showing that side.
Maryam?
Yes.
She can screen share. Dr. Mulutsi, you can. Yeah.
Can you share it that side? It looks like here there's something happening.
There you go, Dr. Mulutsi.
Yes, they can put it on the
Slideshow.
slideshow.
Okay.
Okay. Okay. Good morning, colleagues, and thank you again. My apologies for this slight glitch. The host can also activate my video. I think they can do it that side. I can't do it here, but I hope everyone can hear me. Can you hear me?
We can hear you, Dr. Mulutsi.
Okay. So I will continuously ask for the next slide because it's shared from that side. So can you move to the next slide, please? So in terms of my introduction, it has been already indicated that we have a significant overrepresentation of persons with intellectual disability in the criminal justice system, also in the general health system, and also forensic mental health services. Prof. Nahdi has just taken us through the contrasting views that exist over the association of intellectual disability and criminal offending. And although there is this contrast, there is consensus, however, that the complex histories and the needs of persons with intellectual disabilities presents considerable challenges to the correctional system and the broader mental and forensic mental health systems in respect of their management and rehabilitation. So we all appreciate so far that this is a different cohort altogether from mental illness, and they require different care inputs. Next slide, please. So what are the concerns in the mental health system? Firstly, the main concern, I think that is the main contributory challenge also towards the increased demand for forensic mental health services, is the poor integration of mental health services in the general health services, particularly at primary healthcare level. This is severely inadequate, and it provides a clear direct feedback loop towards forensic mental health services as a backdoor service, a backdoor system for accessing services for our people in general. Prof. Kaliski indicated already that this is sort of a chronic service through forensic mental health services. We have a hospice-centric approach of care. In as much as there have been many initiatives to improve this approach, we still find that there is no separation also of persons with intellectual disability in the general mental health system and in forensic mental health units. So in most provinces, hospitals are the only available placement options because of the limited community-based mental health services that we are faced with. Another critical issue, an ethical concern, of course, is the long stays in specialized psychiatric hospitals within high levels of security. This is very costly. The environment is restrictive, which is not profitable for our users. And currently, we also don't have the determined standard of length of stay in forensic units. The throughput from hospitals poses a greater challenge. So if you look at the number of mental health care users and persons with disabilities who enter the mental health system, particularly at a specialized hospital level, and you look at the number of those that are able to exit the system, there's a big discrepancy. So in as much as we can strive to build more hospitals, more beds to provide for the services, this will not be a tenable solution because it means in a month, for example, we have to build 30 new beds for forensic mental services in the country, which includes people with intellectual disability. Also, within the specialized psychiatric services, starting from primary health care, there has been evidence of poor quality of healthcare with neglect of routine healthcare needs. For example, many persons with intellectual disability, particularly at primary care level, has got widespread dental problems, constipation issues in hospitals, neglect of their physical needs, including chronic illnesses. Next slide, please. Let's move to the next slide. So in terms of investment on human resource capacity, there is limited investment on human resource capacity that will be able to respond to the needs of persons with intellectual disability. Besides this challenge, we have been hardly hit by the impact of COVID-19. Impact of COVID-19 in the country. So this has significantly impacted on the available human resources that we have as a country. Not much that I can say to defend the shortage of specific rehabilitation programs that we have in our facilities. Most of the rehab programs are generic. They are not specific. They are not person-centered. The planning is not involving families and also personal care and support that is required for this specific cohort. Regarding research, we need forensic intellectual disability cohort research, which is urgent, in other words, because we need to understand the specific treatment approaches and the service factors related to treatment outcomes. I think the previous speakers have indicated the gaps in research that is required for us to be able to plan forward appropriate and responsive services for this cohort of users. Regarding policy issues, there's a greater need for a discussion and dialogue around this. For an example, we have to agree as to whether we need specialist inpatient intellectual disability forensic services versus community-based residential facilities for persons with intellectual disability. Which one comes first? Do we have to choose between the two, or do we have to develop both of them and integrate them accordingly between the general and the forensic mental health context? Do we have to have a national strategy for intellectual disability in long-stay forensic units, or do we have to have an integrated forensic mental health policy? We are all aware that currently we have a policy a national policy framework that is expiring. It needs to be revised. So this discussion and decision is very urgent so that we can decide as to whether we integrate this input in the revision of the policy, or we have to have a separate policy framework that talks to forensic mental health issues. Next slide, please. What are the concerns in the criminal justice system? There's a number of issues really that have been touched on already, but we all appreciate that persons with intellectual disability are significantly disadvantaged in the criminal justice system. The implementations of options that have been provided in Section 77 and 78 of the Criminal Procedures Act have not been fully implemented. Legal representation from the earlier stages of the process needs attention, because we found that most of the users and also persons with intellectual disability are not legally represented during particularly the earlier stages of the process. The diversion from the criminal justice system and forensic mental systems to general mental services and community care also needs to be strengthened. That is why we have many persons with intellectual disabilities still being declared state patients, although there is provision that they can be diverted towards involuntary mental health care services. The main challenge, I think, in the criminal justice system is for the system to have an early identification mechanism where persons who are disadvantaged by various forms of intellectual disability, which in most cases are subtle, can be identified early on time and be appropriately protected according to the available protections. Next slide, please. So we need to have a program of action to transform the services for these persons. And I'm recommending that the program of action that we must have must be informed by the following principles. It must be informed by a life course approach, must be responsive to the human rights needs of persons, must be provided by skilled workers. It must consider value for money so that we don't invest the services at a high level, ignoring the investment at primary and community level. And then it must adopt an integrated care approach so that in cases where inpatient services are required, planning for family and community reintegration must start from day one of admission, which is not practiced mostly in our facilities. Next slide. So what are the proposed actions? Where I'm sitting, I think this can also inform the discussion and the dialogue in this forum. To say that we need to review the model of care for persons with intellectual disability. So there is work that has been undertaken by the Department of Health to develop a model for community-based mental services, and that work has been started. Consultations are underway so that we can draw lessons from all other, available services globally, locally, regionally, and come up with a context-specific model for rehabilitation or community-based mental health services, including persons with intellectual disability. We have seen pockets of attempts in various provinces, but there has been many issues and challenges that came forth, because I think the reason is that this has not been adapted to speak to specific issues in our country. We have to develop rehabilitation programs that are structured around specific needs for persons with intellectual disability, and this substance misuse and abuse. We must continue the partnership within the criminal justice system and other stakeholder departments such as the Department of Housing, Department of Labor, Social Development towards an integrated management approach. So the mandates, the legal mandates for each of these departments and the agencies must be clearly specified so that, for example, social development takes their responsibility regarding management of intellectual disability, the relevant cohort, and Department of Health also takes up the responsibility for management of intellectual disability in the general context. But this must also feature up to the forensic units because we haven't seen that much interaction in the forensic context in the management of persons with intellectual disability. We have to engage further with the criminal justice system to ensure that the protections that are offered in the Mental Health Care Act and the Criminal Procedures Act are provided for. So that, for example, the sentencing options for persons with intellectual disabilities are very clearly specified and they are different from the other general population and other categories of mental health care users. There needs to be legislative and policy reviews so that a system for persons with intellectual disability within the criminal justice system and the health system is strengthened. For example, the inputs that Prof. Kaliski was talking about that we submitted to the Department of Justice to inform the review of the Criminal Procedures Act talks basically about issues around preliminary screening, diversion mechanisms, the period of certification, which is not stipulated. So it's unto the court to decide for us, in other words, when we make an application for reclassification or discharge of our users. We need to also see the role of clinical psychology be strengthened within the criminal justice system, particularly in handling persons with intellectual disabilities who came into contact with the law. The discharge processes currently is a legal process, whereas there is so much from the clinicians that can be, delegated to the treating clinician to decide when they can discharge and just provide reports and recommendations to the courts. Not the way it is currently practiced, where the decision lies at another department away from the clinical discretion of the treating clinician. In terms of resourcing and funding for services, this is another interesting and very big issue. We have started a project to develop an investment case for mental health services generally in the country. So this will include a whole range of mental health services, including persons with disabilities, so that the investment case can identify the priority interventions that this country can undertake to improve the services in general. Next slide, please. Advocacy, information, and public awareness are very crucial. We have been very silent on information and family support for intellectual disability. Not much has been said around this area. And this will help also to include self-advocacy and self-help skills for persons with intellectual disability. Prof indicated the role that stimulation and support can have in the development of responsibilities and self-care for persons with intellectual disability. I think if we can start through improving information sharing, advice, and advocacy programs around this area, we can have a good start to improve self-advocacy and self-care by the persons themselves. The auditing of the current service provision is another key intervention that also Prof. Nahdi indicated, that we need a baseline. For now, we are just talking in general terms. I also have a database at the national office, but I'm drawing the database from the periodical reports, review reports that are submitted, on each of the users. So I cannot give you the exact number of persons with intellectual disability within our forensic units. So I think we need to have established a baseline, for an example, on the number of persons with ID in our hospital settings, a snapshot of service provision, what services are being rendered, which services have proven to be effective, and which ones, how many have been placed, and the length of stay. I think this will provide really a baseline that will improve our planning and training going forward. We need to have better information and monitoring systems. We can establish key performance indicators and minimum data sets that can be collected through provincial indicator data sets or the surveys that can be conducted, at individual provinces or even at facility level. Next slide. So in conclusion, I think for too long, persons with intellectual disability have been too much out of sight. And this is the confession I think we also have to make, all of us, across all levels of the service. Although there are pockets of opportunities and a number of examples of good practice globally, internationally, even locally, and regionally, in too many places, the needs of this highly vulnerable group of people are not fully addressed. So I'm looking forward to the recommendations from this dialogue so as we can have a blueprint towards reshaping the services for persons with intellectual disability in our country. I thank you.
Thanks so much, Dr. Mulutsi, for that presentation and for, I think, acknowledging the very reason why we've decided to embark on this conference, because people with intellectual disability in the forensic system have been out of sight for far too long. I think your presentation also appreciates a lot of the challenges that we face at a national level as well, and highlights the desperate need for us to do research and to engage with dialogues with a variety of stakeholders. In terms of questions for you, there's a comment that in the Western Cape there is an ongoing process of engagement where they're trying to do an audit across all the hospitals in terms of intellectual disability. I'm not sure if Dr. Mulutsi is aware of that.
So each province is engaging in different activities to try to come up with plans to improve the service. We welcome the findings and recommendations that will be made through the Western Cape initiative, and that will fit into the plans that we are putting in place at the national level. There's nothing that is stopping provinces from auditing their services. This is actually what is being encouraged because, as you know, the contexts are different. So also the inputs may differ from province to province. So that process is highly welcome. We are looking forward to engaging further if we need to give input at the national level.
Okay, and then there's a comment previously regarding prevention, and that actually entails establishing capacity and services that intervene with persons with intellectual disability prior to them actually becoming forensic patients. So in other words, the pre-forensic stage when they start to have brushes with the law. And to date, it's sort of felt that a lot of the focus has been on the healthcare system. And the question was whether other departments such as social development, education, and perhaps the NPO sectors are going to be joining these conversations as partners to the healthcare system.
Yes, true. That has to happen, and that is happening. And we have encouraged also that there should be intersectoral fora at provincial level, also at district level, even at facility level. There are facilities which we encourage that has got specific fora with all the departments that involved in the criminal justice system, also for forensic mental services. So the legislation also make provision on the legal mandates per department. For instance, we know that social development has got responsibility for mild to moderate persons with intellectual disability, and the health needs will then fall into the responsibilities of the Department of Health. I think the policies are in place, the guidelines are in place. What is lacking is the implementation thereof.
Okay, so further comment was that perhaps integration into the National Strategic Plan might be useful for ID and forensic services as well. So is there something in process around that?
Yes, we will be starting. Actually, the process has started to review the current mental health policy framework, and we will, embrace all inputs that will come, because I think recommendations from this conference will also give specific directions on what needs to be integrated in the national policy. The window of opportunity is open, colleagues. We would like to hear from you. What is it that you would like to see featuring in the National Mental Health Policy Framework? And the question that I asked was that, do we need a specific forensic mental health policy, or should we continue the route that we have been undertaking of having an integrated policy? Both have got pros and cons, but we have to really interrogate the process and see the direction that we'd like to take. We know that if we go the integrated route, we have to put strong mechanisms to ensure that the specific features and needs for specific categories of users and persons with intellectual disabilities are not lost in the mist. If we have a specific framework, policy framework, we know that the chances are that it may then be separated from the general processes, and we may not enjoy the proper support and attention we need. So we have to balance the two and see how best we can be able to provide a response that will provide adequate support and protections for our people.
There's another comment as well that perhaps this takes us back to the ambitious goals of the NPA 1994 for us to function preventatively and not just in terms of prosecution. So I think there's a large suggestion towards us doing a lot of preventative work as well. Then there's another question for you, Dr. Mulutsi. Do you think that the presence of intellectual disability will in future still be used as an exclusionary measure to access other existing services, for example, substance abuse rehabilitation? Or will there be a type of convergence and adaptation of services to accommodate this cohort?
I think the second part of the question is the answer itself. Yeah, because there is no way that we can promote, separation and also stigma and discrimination of persons with intellectual disability. I think it starts from advocacy, from us as health providers, the policy planners, the persons themselves, and also the community. So integration is the key.
And the last question I think that we'll have time for, Dr. Mulutsi, is whether the time frame for input to the review of the National Mental Health Policy has been set already.
Yeah, I saw also who sent that question. Sharon, I'm aware that you'd like to know more about this. We can share more detail with you, but for now I cannot commit to a specific time frame. I've been started, and remember, this also came from the recommendations from the Human Rights Commission report that there should be a stakeholder forum established at the National Department of Health, and one main responsibility of that forum is to review the policy framework. So we've had a number of meetings. Nominations have been made through the stipulated departments. So meetings have been started. I think this will be an open process. So that's why I would really want us to come up with a blueprint for how we recommend we transform services for persons with intellectual disability, so that already from this conference, we've got a concrete input towards the national policy framework. And that will be really appreciated, because in this case, I don't think we'll then come back and say we have omitted this cohort. And I really want to thank you so much for this opportunity and really considering me for invitation and participating in this conference. I hope my input gives some direction and appreciate it. And I thank you for listening to me. My apologies for the technical glitches.
No problem. Thanks so much, Dr. Mulutsi, and especially for the invitation for us to contribute to the reforming of the services for this cohort. Thank you so much.
Thank you.
Okay, I'm going to now be moving on to our next item in the conference and introducing two of our guest speakers. The first one being Justice Saldanha. Justice Saldanha has been a judge of the Western Cape High Court since 2008. He has had a long history as a legal activist in our country, playing a pivotal role in promoting transformation within the legal fraternity. Justice Saldanha continues to maintain a deep and enduring engagement around issues of human rights and transformation in the legal services. So welcome, Justice Saldanha. And together with Justice Saldanha, we'll have the dialogue with Dr. Peter Smith, who, as most of us know, is a psychiatrist jointly appointed to UCT and the Department of Health. He is extensively involved in undergraduate teaching as a senior lecturer at the University of Cape Town, and our lead psychiatrist working at Alexandra Hospital, who with a small committed multidisciplinary team offers comprehensive services that address the mental health needs of individuals with intellectual disability across the lifespan. Welcome, Dr. Smith.
Thank you. Can I just check if Justice Saldanha is here? Ah, right. Okay. Welcome, Justice Saldanha. Could I just present a rationale for this presentation? It really reflects upon an evolving conversation I've been having with Justice Saldanha over the past few weeks, really, and it emerges from I discovered mutually shared deep concern between the enduring gaps between the lofty aspirations that are embodied in our constitutional order and the real life experience of people with intellectual disability. And so on the basis of that shared concern about addressing that gap, this conversation has emerged. I thought that it'd be quite useful for us to share some of the content of our conversation, since there are very few formal forums for connection between clinicians, mental health practitioners, and officers of the court. Most of that interaction takes place through the Mental Health Review Board, and often communications from the bench are received with quite a lot of trepidation by practitioners. And I just have one of my, I've just had one of my patients intrude for a minute. So many of those communications, as I've said, come in an atmosphere that is fairly tense when we feel that we're being held to account. But I thought that in the conversation so far, we've been able to address some very important matters that have been addressed so far this morning. Just to say that what I'd like to focus on now are issues revolving around patients outside of the forensic service. That is to say, people with intellectual disability in the general psychiatric services across the lifespan. So that is the rationale for this conversation from my point of view. I'd just like to offer Justice Saldanha an opportunity to say why he has agreed to participate today.
Good morning. Can everybody hear me? Can
Yes,
you hear me?
we can hear you, sir.
Good. Well, once again, good morning, and thank you to Dr. Smith and the conference organizers for inviting me to be part of this important dialogue. So when I was first asked whether I was interested in participating in this conference, I really wasn't sure why was I being asked, because I really have no particular expertise in the area of intellectual disability. But I do work on a daily basis in the courts where we deal with people who display mental illnesses, and we attempt to the best as we are able to as judges to deal with them fairly and justly. And so when I discuss it with my colleagues as to, do we fully appreciate the differences or the difference between persons with intellectual disability and persons with mental illness, there is a gray area amongst us because we don't make the distinction. And that to me was one of the important caveats I have to disclose with everybody up front, is that we don't do that consciously and we don't do it properly. And I suspect because we don't do it consciously, we might in fact be undermining the very rights of people with intellectual disabilities. And in fact, we might then be treating them unfairly. So what this dialogue has done is to certainly highlight for us the distinction, but at the same time the overlap. And how do we as judges and the judiciary in general begin to be a lot more sensitive to the issues of people with intellectual disability, because we use it very often synonymously. And so I thought I'll start off and tell you how gray this whole area is for us as judges. But first, let me say that people with intellectual disabilities and mental illness confronts the courts in a number of ways. Firstly, in our criminal justice system, and that's in the area of criminal law. In the second area, which many of us have to confront with on a daily basis, is in civil law. And there in particular, where we are dealing with huge damages claims of people involved in accidents, in particular motor car accidents, in which people may, as a result thereof, have a mental illness or brain damage, or have a predisposed intellectual disability. How do we deal with them? And very often, and in most cases, we simply rely on the reports of experts in order for us to come at a figure for compensation. And so what we have to do is to firstly find that the person has suffered an injury which affects their ability to participate further in society and in the workplace. And then we have to arrive at a magic figure. And there we rely a lot on the experts. And the third area, which has become increasingly important in South Africa, is in the area of public law. And so my sense for many judges and legal practitioners, and I suspect for many people in government, there is the world before life esidimeni, and there's a world and a life after life esidimeni. Now, the importance of esidimeni is that it brings a particular junction into our discourse in South Africa as to how do we deal with people who are vulnerable. And in particular, what esidimeni teaches us is how we fail them. We can't have 144 people dying and then life goes on as normal for the rest of us, where there are responsibilities and issues of accountability. But I will come back to the issue of life esidimeni in my closing remarks, because I want to read an extract from a recent book by the retired Constitutional Court Judge Tigang Moseneke in his latest book, where he deals in a chapter on his arbitration in the life esidimeni saga. I will leave that in my closing comments. I thought, let me share with you what one of our leading authors in criminal justice, many of you who've come to the courts and whom we've dealt with in courts on a regular basis, in particular, Professor Kaliski and Professor Zebom. Professor Kaliski in particular, I always like the ties that he wears. Yes, these artistic ties that distracts the judge from concentrating on the evidence and tries to make sense as to what tie is he wearing today and what signal is he sending out to the court. That on a lighter note, and he'll show you his ties hopefully before he retires. So what Heemstra tells us, and this is one of the leading authorities in criminal justice, when we deal with the issues of criminal responsibility, and as you know, the first requirement under Section 78 is a determination of mental illness or mental disability. So this is what Heemstra says. The first requirement of subsection 1 is that there has to be a mental illness or an intellectual disability. The legislature uses the two terms as if they have different meanings. Where the borderline between them lies is not clear from the legal literature, commission reports, or statutory text. The probable distinction between the two is discussed more fully, and they refer to an article in the Tate Script for Law, a 1974 article. But he goes on to say, for practical purposes, they are always used together without an attempt to distinguish between them. And then, of course, there was the amendment in 27 that replaced the phrase mental defect with the term intellectual disability. But he continues and say, no new meaning was intended. So the point is that when the authorities in law and the authors of textbooks which we use on a daily basis says, well, we're not too sure why the legislature has made this distinction, then I think what this dialogue does today is to say, we need to understand why is there no distinction? And if there's no distinction, are people falling through the cracks? Are people with intellectual disabilities or people with mental illnesses simply being dealt with the same? And what I've heard today, certainly it's not the same. So those are the opening remarks that I wanted to share with you and all, is that this is an area which judges, because of what we are told in the legal literature and because of our own limited experiences in forensic science, we don't make the distinction. And because we don't make the distinction, I suspect we might be making serious mistakes. Thank you, Dr. So.
Thank you. I mean, that does open very nicely an initial component of our discussion, which should be to look at the current legislative framework and to look at it very critically and to identify exactly these kinds of gaps. So, for example, our legislative framework, as we all know, is based upon the bedrock of our Constitution and the Bill of Rights. And it also is based upon our signatory status to several global and continental conventions around the protection of vulnerable people, including children and people with intellectual disability. And then, of course, in terms of legislation, the key legislations that apply to us are the National Health Act, the Mental Health Care Act particularly, and then for children and adolescents, we have the Children's Act, which many of us regard as a very assertive document in the way that it guarantees the inalienable rights of children. And then for older people with intellectual disability, there is recourse to the Older Persons Act. So within that legislative framework, we think there are some gaps that we can speak about. But in terms of the Mental Health Care Act specifically, I think you've alluded to something that does exist as a problem. And, you know, just as a slightly a throwaway line, in intellectual disability, we're accustomed to being left behind. And in many respects, the Mental Health Care Act was a significant step forward. Unfortunately, it didn't embrace the needs of people with intellectual disability in that leap. And so in many respects, the current Mental Health Care Act does not specifically and unambiguously, you mentioned that issue of ambiguity. The current Mental Health Care Act does not unambiguously address the very particular needs of people with intellectual disability. They do have mental health needs, but they in many respects are distinct from the kinds of needs seen by people with mental disorders as they're conventionally understood. So that does represent a significant deficiency that ought to be addressed in terms of the Mental Health Care Act. But beyond that, in terms of the execution, in terms of the operationalization of the Act, there are a whole host of difficulties that we encounter. And I think that you probably witnessed that in your role as being the ratifying judicial officer, when you see the often unsatisfactory way in which the regulations are followed, the lack of fidelity to both the content and the spirit of the Act, and the gaps in terms of accountability in terms of that. So I'd like to hear your comments about those specifically.
Thank you, Dr. Swartz. Well, as you know, people who become involuntary patients at many of the state institutions, their extended stay at the institution has to be, in a sense, ratified after the Mental Health Care Review Board makes a finding and then comes to us to consider the file and the documentation and to make a decision as to whether the person should be released immediately, which invariably no judge would likely take because of the risk of consequence. But there's also the provision that we may extend the stay for a further period. What then in fact happens is that when the file lands on our desk, and normally it's in a pile of about 10 or 20 files that comes to a judge at least once every 3 or 4 weeks, we go through the files and we go through each one of them and we try to make sense as to firstly who the person is and what is the person's condition. I don't recall seeing any distinctions being made on those files between an intellectual disability or people very often who simply as described as being psychotic or schizophrenic or having a bipolar condition. And then of course there's a part which is very rote in the form where it says the person is a risk to himself or herself and to people around them. And then there'll be a small part that would tell us why the person was admitted, either by a family member or a friend, or sometimes by the police, or even sometimes by a family physician. Very little of that we really fully understand as judges because our training is not in forensic sciences. But we then have to make important orders about whether people should be detained further under the provisions of the Act. And so one of the issues that I raised with Dr. Smith is that sometimes we aren't even fully able to read the handwriting on the forms, besides us trying to understand it. So the forms are very important for us because we have to make important decisions about somebody's liberty. And to the extent that we take people's liberty very seriously, whether we detain people longer in an institution or not is very important. And there could be very serious consequences if we're making mistakes because we don't know what we're doing. And so there's a shared responsibility between the judges and the people, and there's at least 3 or 4 people who fill in the forms. We see the different handwritings.
Yeah.
So there's a greater mindfulness that we need with regards to that process. I remember when I had first raised it with Professor Sutcliffe, he said, Judge, you know, there is a fire that's burning out at our institutions. You have no idea as to the amount of pressure that we work under. And so we invite you and your colleagues to come and do an inspection with us, and we'll show you around the various wards. So we took up the offer, and we've thus far been able to have visited Lentegeur and Valkenburg. And those were 2 remarkable inspections and encounters, because as judges, we actually saw firstly the clinicians and the doctors and the workers who were providing this important and this very difficult service. And they gave us briefings and they explained to us what the different terms means, and they explained to us how they deal with it. And then we were also, in our last visit at Falkenberg, we had the privilege of being able to listen to an interview with one of the persons who was being held there. And it was an extremely, firstly, just for people who don't interact with people in a formal basis, on a day-to-day basis, it was traumatic. And it was a sense of misbelief by us. But there was also a sense of fear, a fear of the unknown. And that we were, in fact, all of us were responsible for the lives of these people to be able, hopefully, to make better decisions in life about themselves. So that was an important lesson for us. I said to Dr. Swartz that when I practiced many years ago in the criminal courts, one of my clients was referred for observation to Falkenberg. I think it's Ward 20 that it's called. And I went to visit him, and this must have been about well over 20 years ago. So things, I suspect, has improved significantly. I went to consult with my client at Ward 20, and I walked away with a sense of feeling that I would not want my worst enemy to be sent to Ward 20, because I was shocked at what I saw. And for my client, who had literally deteriorated in a matter of days and weeks, he had become a lot more incoherent. He was very suspicious, and the voices that he did say that he was hearing had now become louder. And so it left me with a sense that Ward 20 should be one's last resort and not the first resort. We need to be very careful when we send people for observation, that we don't simply, as judges, allow legal representatives to be using the system for the wrong reasons, or for lazy reasons, or opportunistic reasons. But more importantly, that when they do go there, they're able, that is in their best interest. Sure. And I know that very few people who go for observation would be able to fool either Professor Zebo or Professor Kaliski. So I will share this with all of you, is that in the court, people says, well, Professor Kaliski will sort him out. We'll get the report. And there's nobody who's going to be malingering or pretending that's going to be able to survive a report or an interaction with Professor Kaliski. So I hated that if ever Professor Kaliski was to leave, that there'd be somebody else who would provide that sense of guarantee for us. So that's the one area where I thought I'd share with you. The other area is that I'm one of the judges who's responsible for signing off people who are state patients. And there I'm impressed with the rigorous process that in which Professor Kaliski and the other people are involved in, and the Office of the Provincial Director of Public Prosecutions, who act as the curator for such persons. And it gives me no greater joy than to be able to release somebody either conditionally for 2 years or 1 year, and then 2 years later or a year later, I get a further report and says the conditional release has expired, it can now be made final. There's no greater joy, because it means somebody has been reintegrated in society. Somebody's family has risen up and says, we are going to allow this family member to become part of us. And that's going to take me to something else I want to share with the participants, is the whole notion of communities and the role of the communities in the rehabilitation and the absorption of people, not only with intellectual disabilities, but also with mental disabilities. Now, Esidimeni was the wrong process, and there are serious problems. But I do believe that there's a tremendous amount of social goodwill in our communities, and that brings me to this whole concept of the role of Ubuntu in public health. Now, I have a son who does lots of research for me and who is doing a master's thesis on Ubuntu. So we discuss Ubuntu very often and also with colleagues. Now, the important issue and notion about Ubuntu is that it really provides us as judges and also as clinicians that how do we recognize what is called almost the social capital or solidarity and the ability and the willingness of people in communities to be receptive to care and to assist and to protect and to shield. And how do we capture the spirit of Ubuntu in our communities in order to facilitate the whole process of people reintegrating? And so on that, I simply want to refer all of you to a very useful article by a Professor Chuma Imongo at UCT. He's the chair of cultural law, and he does this fascinating article. It's called The Right to Health in African Cultural Context, the role of Ubuntu in the realization of the right to health, with specific reference to South Africa. So if you are able to just go through the CS website in Cambridge Law, and you'll be able to find an extremely useful and important article. Because what we really want to do is that, there's this whole notion that human rights is a Western concept, and we forcing this notion of Western human rights on communities. What Imonga argues is that the value of Ubuntu gives context and meaning to the rights that we talk about in the Constitution. So Dr. Swartz, you referred to all of the rights in the Constitution. We have one of the most progressive constitutions in the world. We have the strongest rights around dignity and equality. We have the strongest socio-economic rights in any constitution in the world, even though they are simply access rights. Section 27 is an access right to health, not a direct right, but it's an important right. And we've seen how that right has been actualized in the TAC case and in many other cases before our courts. So we've got strong rights in our domestic constitution. We've got strong provisions in the Mental Health Care Act, in the National Health Care Act, and importantly in the Children's Act, Child Justice Act, and the Criminal Procedure Act. How do we use this? So besides the legislation and the Constitution, and of course, as you correctly point out, all the international obligations that we have signed up to, and the regional obligations in the African Charter, there's also a burgeoning body of law by the courts since 1994, grappling with how do we make these rights in the Constitution, we give meaning and content to it. And so they're very interesting cases that over the many years our courts have grappled with. But in an article which you, Dr. Swartz, and others had written, and which you kindly referred me to, on the scoping of intellectual disabilities. What I found was the fascinating sense that it's not only the rights as we refer to them in the Constitution, such as the right to equality, the right not to be unfairly discriminated against, the right to dignity, to healthcare, but there's this new notions and this new language of rights. And the one right that I was particularly fascinated by when it comes to people with intellectual disabilities is the right to be understood. I thought that's one of the most powerful rights that the clinicians and the academics have put before us, and says, how do we give meaning and content to the right to be understood by people with intellectual disabilities? Because really that's the challenge. They have an entitlement to be understood, and we have an obligation, therefore, to understand them in a language of theirs. And if we don't understand their language, we better find a language. We better find people with aids and people who can interpret what they're saying to us. But if we don't understand them, then we violate their rights. So I want to leave it at that.
Yes, Justice Saldanha, yes, of course. I mean, there was much more that I would have had in mind to speak with you about. We have unfortunately consumed most of our allotted time, and there may be some questions.
There are some, Peter. So I'll pose them to both yourself and Justice Saldanha. But Justice Saldanha, thank you very much. We were very happy to hear that Prof. Kaliski's ties are appreciated in the courtroom as much as they are in our ward rounds. And thank you for acknowledging that people with intellectual disability in the legal system are a grey area. I think in a lot of the disciplines, I think that's what we're really saying and highlighting the importance of us trying to clear that up. So Dr. Mulutsi has sent some comments around, well, the one comment was that it's an important lesson for us to make sure that the forms we submit to court are actually clear and concise. And then she's asking, what is your take if we recommended mental health courts or having a dedicated judge for mental health services per province? So would somebody be dedicated to process sort of applications for involuntary admissions, discharges, and reclassification of state patients? So she wanted your view on that.
I think it's a load. For some judges, it might be a burden, but it's a load that's shared equally amongst all of us, especially on the mental health reviews that comes to us. Because as I say, it's a pile of about 20 or 30, and they do pile up very quickly and very fast. I think any judge would say it would almost be a burden for her or him to be saddled with that. It's important that other judges also deal with these issues, because other judges and all judges and magistrates need to understand this important function that they have to play. And having a special mental illness court, it's an interesting concept. I hadn't thought about it. But once again, it's like child justice and family violence and sexual offences courts. Would we be able to sustain such courts, and what expertise would be required? I think it's an interesting idea, and it's something that should form part of the ongoing debate.
Of the dialogue, sure, thank you. Then there's similarly to that, there's a question around whether, how much training is given to people in the legal fraternity regarding mental health.
Very limited. I recall my training from university days. And, that was the better part of almost 30 odd years ago, hopelessly inadequate. But the important point is that there has to be ongoing training, and there has to be an ongoing interaction and those in practice, so that judges keep up with the latest developments and the thinking. Some of us still think in terms of old school. Professor Kaliski raised the issue about many of us look at people in court and we're told by the clinicians that person functions at the age of 15 or the age of 9. And that might not be the correct way of dealing with it. Which other ways should we be dealing with this? And we're very dependent on the good expertise that comes into our courts by clinicians, whether in the criminal justice or whether in the civil area of our law. And very often, let me just make this point about the civil law, because that's an area which is neglected. When people are about to receive huge amounts in damages, anything over R1 million, and the first thing the attorney says, we now have to appoint a curator bonus for this person, because we don't think that their family, we can trust their family to be able to assist them in looking after the money. In fact, what the family is going to do is that they're going to buy a taxi or a house, or they're going to squander the money. That is so disempowering for people. And so we are very critical about when we've been asked to appoint a curator bonus, and equally a curator persona for people, because how it infringes the agency of people to be able to make decisions for themselves. And so they're very, very often, we find that the recommendations for curator bonus are by the professions outside, the experts who come before our courts, who prepare reports on a regular basis. It is almost what some of us refer to as a bit of a cottage industry for curator bonuses. where they then get, in what I regard very often, a very patronizing way to manage the affairs of other people. Because we don't have no confidence that either them or together with their families or a close family member can make decisions in their best interest. So I thought I'll just flag that for consideration at some future point in time.
Sure. So Justice Saldanha, we have run out of time, but thank you so much for participating with us today. I think you've shared a lot of value.
Can I just read for you one paragraph from what Chief Justice Moseneke says about life eccidemene. So he made this huge award of 1.2 million rand to every victim or their family. He says the reason for the award I made, I spelled out the regulatory regime in considerable detail. In my view, this was necessary given the vast human tragedy in the form of death, torture, and the survival of defenseless mental health care users. Also because since 1994, our state has elected a globally admirable and compliant regulatory regime for the care of such patients. Its provisions are by and large in sync with international human rights and mental health care norms of a very high order. But what stands out in the breadth and depth and frequency of the arrogant and deeply disgraceful disregard of constitutional obligations, other law, mental health care norms, and ethics by organs of state, its leaders and employees. In sum, besides the reasons for being untruthful, the decision to terminate the contract was irrational and in blatant breach of the law and the Constitution. Absent rationality in the use of public power, arbitrariness and tyranny will flourish. The death and torture in the life eccidemene tragedy stemmed from the irrational, the arrogant, and the uncaring use of public power. I thought those should be my concluding comments. And thank you very much once again for the ability to share
Thanks
this
so much,
dialogue with you.
Prof. Saldanha. We
Thank
all
you.
share that responsibility. Thanks, Dr. Smith. We're going to
Thank
take now about a 7-minute break, and then we'll resume again at 11:10. Thank you. Thanks.